Welcome to the Knowledge Group webcast, Environmental Risk Management, Principles and Applications. I'm David Jennings. I'll be your moderator for today's event. Now to our panel. Joseph Picciotti is chair of the Environmental Practice Group at Harris Beach. His work is on environmental regulatory counseling and litigation, as well as land use counseling and litigation. Mr. Picciotti has substantial experience representing companies and municipalities in hazardous waste site cleanup, including prosecuting and defending environmental claims involving private parties and municipalities. His environmental practice includes counseling public and private corporations on complying with federal and state regulatory requirements concerning the storage, maintenance, and handling petroleum, hazardous substances, and hazardous wastes. We're going to turn things over to Joseph Picciotti at slide 13. Joseph, the floor is yours.
I'm pleased to be, thank you very much for that introduction. I'm pleased to be part of a terrific panel today with Ken Cornell from Enviant and with Chris Braun from Flu Shadley. As indicated in the introduction, I'll just underscore a couple of things. My background is primarily a litigation background. That's where I started my practice out of law school and actually involved in environmental insurance matters on behalf of some large insurers in the market at that time, which was the 1980s. I was glad to see that Ken admitted that in his bio, so I can admit that now in mine, now that we're all getting a few years under our belts. I do practice with the firm of Harris Beach, which I've been with for going on 30 years now, with offices throughout New York State and New Jersey and Connecticut. It's one of the oldest firms around and is well regarded in terms of the National Law Journal and those types of things. So my topic is managing liability risk facing buyers and sellers in transactions involving environmental concerns. So I will say that my involvement, I'm chair of our, or leader of our environmental practice group, which is actually part of our larger commercial real estate group. So there is definitely a transaction element to our environmental practice, and we have it across the state. And so that's where we reside as a firm, but we have our environmental practitioners throughout each of our offices in New York and practice the gamut of, as indicated in the introduction, the firm practices the gamut of environmental law ranging from regulatory issues to litigation to transactional work, and I have been involved in all of that. Next slide, please. So we'll start out with what I would consider kind of some basic issues when looking at any transaction that may involve environmental concerns. And actually, I'll start with actually a pre-caveat to that, which is I have too often been involved in these transactions, and it's usually later than I'd like to be, which is why I talk about identifying concerns early, where the buyer and the seller are, I would say, worlds apart in understanding whether, in fact, there are risks or potential risks out there. And I will tell you that as long as there is that kind of a gap, understanding gap in a transaction, that it is you're bound to run into problems. So one of the things I would say is identifying these issues early is absolutely critical, and getting some understanding among the buyer and the seller that the transaction involves assets that have regulatory or other environmental issues, contamination issues, is essential, because far too often what I have seen is we're getting down to either we've already, there's already been a term document, submitted term letter, and we're drafting provisions, and the seller is thinking that the property is fine and there's no issue, and the buyer is very much concerned about it, and there is already a significant gap to overcome. In order to identify concerns, the way the federal law has evolved, and in New York, and I think in many states, is that basic due diligence is required by buyers to protect themselves from claims following closing of the property. So as I'll discuss a little bit, the overview is once you become an owner of property that is contaminated and other assets, you are generally speaking, under federal law and under most state law, deemed liable by virtue of your ownership, without regard to whether you caused the problem. So it is critical that the earliest stage of a transaction that due diligence be done to ascertain whether, in fact, there are contamination issues or other environmental regulatory issues associated with the property. The way that is done is through a Phase 1 environmental site assessment. That is the gold standard and is required in order for a purchaser or buyer to have obtained certain protections under federal and, again, most state law, which is that the basic background of a property in terms of documents on file with the county clerk, documents on file with the regulatory agency are reviewed, and any potential issues associated with that property identified as part of that process. The defenses that are most commonly associated with obtaining a Phase 1 or that require Phase 1 be undertaken, and I'll refer to the Phase 1 environmental site assessment as a Phase 1, include what are called, what people refer to as the innocent purchaser defense or innocent landowner, the bona fide prospective purchaser defense, and the contiguous property owner defenses. Next slide, please. So when we start, when we say, well, what does a Phase 1 do? What is the job of a Phase 1? A Phase 1's job is to identify whether under the applicable regulations and Phase 1 ESAs are conducted under the ASTM standard. That's actually an international standard. That standard is also incorporated into federal environmental law, into the Comprehensive Environmental Response Circle Compensation and Liability Act. And so the way that a Phase 1 is conducted is there are specific criteria that must be met in undertaking a Phase 1. And the Phase 1's job is to determine, are there recognized environmental conditions? And I'm not going to read slides because that'll drive everybody bananas, but this is really important. So I'm going to read this part of this slide, which is, what is a recognized environmental condition? And it is, by definition, under the standard, the presence or likely presence of any hazardous substances or petroleum products in, on, or at a property due to a released, past spill, ongoing spill, some kind of discharge, under conditions indicative of, of that release, or under conditions that pose a material threat of a future release to the environment. De minimis conditions, minor conditions are not included in that definition. The other thing to understand about the definition of a recognized environmental condition and Phase 1 ESAs are that Phase 1s are by definition limited to certain aspects of a property. A Phase 1 does not cover, for example, whether there's asbestos in a structure and whether it's friable or needs to be remediated. It does not cover lead or those kinds of issues, lead paint issues and those kinds of structural issues. It also does not cover regulatory issues. That is, if you're purchasing a commercial or industrial enterprise and there's permits that are needed, discharge permits, air, water, it does not cover those things. It also does not cover issues like wetlands. What it really covers is, has there been or may there have been circumstances that have led to a discharge or release of petroleum or hazardous substances in the past, and may that be affecting the property. Next slide, please. So in the event that a Phase 1 is undertaken, and again, it has to be undertaken according to the ASTM standards, which requires that, to go back a bit for what I said a few minutes ago, it requires that common databases be reviewed, which is county clerk's records, local environmental agency records, perhaps EPA records, depending on the circumstances, and that they be reviewed and the environmental professional identify whether there has been a release or a potential for release in the past at the property that's being evaluated. The Phase 1 ESA also requires that the current operator or person with knowledge be interviewed. It also requires in certain circumstances that adjacent owners or operators, I should say, be interviewed about the condition of the site. So what happens if we don't find a recognized environmental condition? Phase 1 comes back and says we haven't identified any recognized environmental conditions. That's good news in terms of the Phase 1 process, because you've now at least potentially identified as what's called an innocent landowner or purchaser under federal law and many state laws. The only caveat to that is obviously ensuring that the Phase 1 has been conducted in accordance with ASTM standards, which is also required by federal law under CERCLA. And at least potentially looking into the other issues we're talking about. If no recognized environmental condition has been identified, then the purchaser qualifies for that affirmative defense. I will underscore which is the innocent purchaser defense. I will underscore that the innocent purchaser defense is an affirmative defense, which for the lawyers on the line, that means that it's not a get-out-of-jail-free card. It's not like you just wave your hand and say, well, I did a Phase 1 and it determined there was no recognized environmental conditions. It requires that you affirmatively show that you undertook that endeavor, that the Phase 1 came back clean, if you will, and that there were no issues. But it's an important tool to have in your bag as an owner if subsequent to purchase environmental concerns or issues are identified either by environmental agencies or third parties. If a recognized environmental condition is identified, then the next question is, what do we do with that? Oftentimes in Phase 1 ESAs, the preparer is asked to make a recommendation based upon the conclusions in the report. If the conclusion is there's no recognized environmental condition, then the recommendation is essentially no further action, nothing more be done. If a recognized environmental condition is identified, then effectively the next step in those circumstances is almost always Phase 2 work. Phase 2 work is described in a lot of ways, but the bottom line is it's sampling. It can be soil sampling. It can be vapor testing. It can be groundwater testing. And I should go back and was remiss in not indicating that Phase 1s, by definition, do not involve any testing whatsoever or any invasive work or that type of thing or any sampling. Phase 2 work, which can come about as the result of a recommendation in a Phase 1, does require that kind of sampling. In the context of, or requires sampling, I should say. In the context of a transaction, if a recognized environmental condition is identified, now it's time to stop and for both the buyer and the seller to say, okay, what have we got? Is this a commercial or industrial property? Did we expect that there might be some kind of an issue? And where do we go from here in terms of a Phase 2? Do we do Phase 2 work? Do we do testing? And what's that likely to yield? I reference that, and you can go to the next slide. I reference that because all too often what happens in the context of these transactions is there's an agreement to do a Phase 1, a Phase 2 is identified, and unfortunately often the buyer and the seller, and it's more problems for the seller, don't realize that there are ramifications for Phase 2 work. The first ramification is you may very well identify contamination which has to be reported to a governmental agency. And now you may no longer have a transaction because the prospective buyer now may be long gone, but you also have a cleanup obligation. And more often than I would care to remember, buyers, I have seen sellers, who were not aware of that fact, and that's a critical fact. So you're now at the point of, we found that we have a recognized environmental condition. What do we do now? What impact does that recognized environmental condition have? We know it has a potential impact on the buyer because the buyer may be buying property that subsequent to closing, when the buyer is in title, he or she may be liable for contamination on site. But the broader question is, how is that going to impact the use of the property, and what is the expectation of the purchaser in the transaction? For example, if it involves a commercial or industrial use, it's known that the area has had commercial or industrial uses for a significant period of time. The purchaser may be looking at it as, I'm going to operate a factory, I'm not looking to turn around and sell the site for condos in 20 years. It's always going to be a factory. What is the phase 2 going to get to me, and what get for me, and what do I do now to protect myself? So that's a critical juncture for consideration at that point once a recognized environmental condition has been identified. Next slide, please. So the purchaser faces potential liability, as I indicated, if there's contamination on site. The purchaser may also have a concern about whether the site will be impacted by that finding of recognized environmental condition as it relates to how that site may be used. If that recognized environmental condition is going to substantially impact the use of the property, vis-a-vis, is there going to have to be a cleanup, that type of thing, that may be a point where the parties part ways. Does the agreement at that point in the transaction example, what does the agreement contemplate? Often agreements don't contemplate anything. There'll be standard stock language saying, well, a purchaser can do the phase 1, and it has to be, the results of it have to be satisfactory to the purchaser. Well, if they're not satisfactory to the purchaser, very often there's no language that deals with what's the next step. When you get to this step, it's very important, if a recognized environmental condition has been identified, to identify where do we go from here, who pays for it, and how do we deal with a cleanup. It's important to note, again, that when we get back to talking about liability issues, that a purchaser has to be aware of, as an owner of that property, it may be liable not only for future cleanup costs, but also what are called third-party claims, potentially by nearby property owners, but it also may be liable for natural resource damages, claims by nations, including tribal nations, tribal governments, for contamination of rivers or habitats that has emanated from that site. Next slide. So phase 2 activities, we talked a little bit about what they encompass, and we talked a little bit a minute ago about what happens if the purchaser is now in the position to saying, I don't want to, I don't want this. I want to opt out. I've had enough. I was looking for a property where I didn't have these kinds of headaches and complications. And so there may be an opt-out provision. If there isn't, and as I indicated in this slide discusses, if the agreement's silent on those issues, it's time to go back to the drawing board and figure out what to do next. In any event, if the transaction's to go on, and it's going to be off life support, then there has to be a plan as to what the phase 2 activities are going to be. As I indicated a minute ago, if contamination is found, who's going to advise the regulatory agency? Because once that is found, there's likely to be some investigation or cleanup obligation, and frankly, the owner is going to, in New York, the law was recently changed. The owner is now required to do that investigation. In the past, it was anyone with knowledge, so that's changed a bit in New York. But you're going to want to control that as a seller in particular, because you're not going to want some third party contacting the local environmental agency or the state environmental agency and kind of blowing you in and then losing control over that cleanup. Next slide. So if the phase 2 work is to be undertaken, the question is, who's going to pay for it? What are the criteria associated with that phase 2 work? Is it likely that if the problem is even larger than one could imagine, is there another opt-out at that point? That is critical. And last, as a purchaser, is there adequate time in the transaction, if there is phase 2 work to be done, to allow for that work to be completed, that phase 2 work to be completed, and frankly, any remediation to be completed before closing? That is the ideal situation for a purchaser, that will happen before closing, because then the purchaser doesn't have that headache and doesn't have that issue on its plate when it's after it closes on the site. The other thing that has to be nailed, the other issue that has to be nailed out at that point, if Phase 2 activities are to be undertaken and it's expected that some remediation is required, what is the benchmark that's going to be used to say it's cleaned up? Most people point to the environmental agency that has jurisdiction. Issuing, in New York, we call them no further action letters. They used to call them closure letters. There is no such thing. Those determinations are filled with caveats, and they're basically allowing the agency to reopen. But basically, the agency says, "Hey, you've done enough, and we'll leave you alone for now." But that's generally the benchmark that's used to determine whether the cleanup has been completed. Next slide. So if the remediation cannot be accomplished by closing, hey, this needs to happen quickly, or the seller has said, you know what, I want out, I've had enough. The purchaser has said, you know what, I'm ready to take on some risk, and Ken and Chris will talk to you about how to deal with those, Ken primarily. But is there some other creative way among the buyer and the seller to deal with the issue? Can there be an agreement on the potential cost after the Phase 2 is completed and we know a little bit more? Do we have an idea of what the cost of that cleanup is going to be? Can we set up an escrow where the part of the purchase price funds the escrow account, so that if after 3 years there's no contamination that's found, or the cleanup costs half as much, that the remainder of the escrow is released and returned back to the seller? So those are the kinds of things that tools that we have seen in the toolbox for transactions to deal with these issues. The other obvious one that's talked about all the time are indemnities. Can the seller provide an indemnity to the purchaser that the purchaser can rely on? Frankly, it's very difficult to rely on indemnities for all kinds of reasons. You can discuss with a corporate lawyer, but the bottom line is most indemnities aren't worth all that much because the entities standing behind them are not going to be around long enough for those entities to make good on a claim against it. The other question with an indemnification is, so how's it going to be funded? Frankly, unless it's funded by something like a letter of credit or some ready available cash, I'm always very skeptical about them. The other question is, how long is the indemnity going to run? If the transaction document has reps and warranties in it, there's a 6-year statute of limitations on those being breached. The indemnity, in my view, if it's to be effective, has got to be at least as long as the statute of limitations, if not a bit longer. Lastly, is the buyer, in the absence of all those, is the buyer willing to take on some risk following a closing if contamination can't be cleaned up and there's no escrow or that type of arrangement available, and or the indemnification is either unreliable or not available? Next slide. So if there isn't sufficient time to do the cleanup and there are other complications associated with having an escrow arrangement or some other arrangement to take care of these issues, what do we do? What does the purchaser do? Does the purchaser walk away or not? Well, one of the defenses available for purchasers is called the bona fide prospective purchaser defense. That was a change in the law that's happened some years ago now, which was a welcome addition to transactions with environmental issues, because basically what that provides is, there's some risk to it, but what it provides is that as long as a purchaser acts appropriately in purchasing a property where environmental conditions have been identified, then that purchaser may assert the bona fide prospective purchaser defense to claims. The difference between the bona fide prospective purchaser defense and the innocent purchaser defense is, the bona fide prospective purchaser defense is the purchaser continues to have to demonstrate that it is taking appropriate actions even after closing. And so there is some risk involved in it, and the risk is that the post-closing what's found is something worse than was even contemplated by the Phase 2 activities that were undertaken. Next slide. The other tool that is available, which Ken will go into in great detail, and I looked at his presentation, it looks excellent, is environmental impairment liability insurance, sometimes called pollution coverage. That is another way to deal with risk. The price of it from a transaction lawyer perspective has changed dramatically. It's much more affordable than it used to be. The market is still changing a bit, and Ken really knows the market. But those coverages are available. There generally are what are called paid-up premiums. They're fairly significant deductibles, but it can be a way to bridge the gap in transactions where there are environmental issues, and frankly an indemnification is not available, escrow is not available, and or there may not be time to do a remediation prior to closing. I will add one quick thing, and I'm sure that Ken may hit on this or it may be the subject of a question. One thing you do need to be careful about is if you're going to decide to use environmental impairment liability insurance and you're weighing all of the options available, that has to come into play fairly early, because if you're doing all kinds of Phase 2 activities and you're still considering environmental impairment liability insurance, you can put yourself and your insurer in a position where your coverage is not available, either because you've discovered such a problem that it's not insurable from the market's perspective, or you've taken yourself to the point where there's no insurable risk. So, again, and Ken may be, in fact, dealing with those issues. Next slide. So I am going to conclude, because I know we're going to hold ourselves here to the 20 or 25-minute mark, and I look forward to any questions that folks may be sending in.